Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Texas Attorney General Concession on Appeal. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, I need you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also, hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so this will be a powerful video, guys. And the reason why I'm doing this video is because one of my ox that I'm helping on his appeals case in Texas, we received some good news, guys. And like I tell you all, you know, you must continue to apply that pressure no matter what, okay? So I just want to go over the letter that the Attorney General filed into my ox appeal case. But before I do, let's go over the definition for the term concession so you all can understand what concession actually or truly means, okay? So without further ado, let's go to the definition for the term concession. Okay, so now, as you all can see, we're coming from the law dictionary, but let's pick this up where it states the definition right here, guys, for concession. Very top, and it reads, number 1, the right to use someone else's property for business purposes. Number 2, the right to be the only seller of a product in a place. Number 3, an allowance. But as you all know, I have number 4 highlighted because the number 4 definition is the one that fits the definition that we're going to use pertaining to what the Attorney General filed, which is what? It's simply highlighted and it reads, an act of accepting defeat. So basically, when the Attorney General filed his letter into the case for an appeal, he's simply what? Accepting defeat. That's it. That's all, guys. So now that we know the definition of concession, now let's continue to read the letter that the Attorney General filed into my ox appeal case. So without further ado, let's go there. Okay, so now, as you all can see on the screen, this is in fact the letter that the Office of Attorney General filed into my ox appeals case, okay? This letter is considered to be a response to my ox brief, even though the Attorney General did not file a reply brief, okay? No, instead of filing a reply brief, the Attorney General just simply filed this letter and sent it directly to the clerk of court. Right? So after reading this letter, you all will have a better understanding of what's going to take place in this case, you know, and basically, you know, you all can predict the outcome. All right. So now, as you all can see, the upper right hand corner, it states, which is in fact the file stamp because it was e-filed. That's why it states accepted. Okay. Further letting you guys know that it was accepted and e-filed into the 5th Circuit Court of Appeals coming from Dallas, Texas. Okay. The document was filed on January 25th, 2023 at 3:12 p.m., guys, which is this month, this year. Again, the case numbers are crossed out as always, all right? In the middle of the page, we have the Office of the Attorney General seal, and also it states the Child Support Division, all right? And it was done on January 25th, 2023, all right? Again, it was e-filed and sent out USPS to who? To Ruben Morin, who is in fact the clerk of court. Okay, which this letter is in fact addressed to, all right, with the address and everything else right there so you all can read it, all right. Again, the Court of Appeals number I crossed out, trial court case number I crossed out. Again, guys, it states style and it states in the interest of, which is my ox child's initials, okay. So I crossed out his initials as well, and it states a child. Then again, it is addressed to who? The clerk of court, who is what? Mr. Morin. And it reads, Dear Mr. Morin, 1, concession. So we know what a concession is, right, guys? We just read the definition for concession. And concession simply means what, guys? To accept defeat. That's it. That's all, okay? So basically, the Attorney General is accepting defeat. But let's continue. It reads, the Office of Attorney General of Texas, OAG, concedes error on 1 point of this appeal. The likely deprivation of procedural due process due to lack of a post-answer of notice of hearing. So again, guys, the Attorney General concedes, right, and simply admits to what? Violation of my ox due process. So once the Attorney General concession and concedes to one error or 1 point that's addressed in the appeals brief, it overturns the entire lower court's decision, guys. And it's just that simple. All right. So, but let's continue. Let's read number 2. Number 2 states what? Reason for concession. And it reads, the OAG concedes error on due process grounds. So again, they basically accepting defeat on grounds that what? They violated my ARC's due process. But let's continue. Appellant may have been deprived of procedural due process due to a lack of post-answer notice of hearing. Appellant addresses this issue appellant addresses this in issue 3 of his brief. So again, guys, on issue 3 of the brief that we drafted up, that my ARC filed into the court, we also addressed procedural due process, okay? But he also have them beat on issues 1 and 2, but they don't want to admit that. So they're just trying to take the easy way out by arguing due process, okay? But either way, we still won that as well. So now, guys, this page 1, let's continue to page 2. Page 2, and it reads, appellant was served with the Uniform Interstate Family Support Act petition on October the 16th, 2020. He subsequently filed an answer on November the 4th, 2020. Despite appellant's answer, the record does not reflect that appellant was sent notice of the hearing that resulted in the November the 12th, 2020 default judgment. Then it states, the relevant case law indicates, quote, when a defendant makes an appearance, the defendant has a constitutional right to receive notice of any trial setting. Again, another quote, it states, the failure to give adequate notice violates the most rudimentary demands of due process of law. Then it states, case law also states, a defendant who makes an appearance following service of process is entitled to notice of the trial setting as a matter of constitutional due process. Case law to support that, guys. Then it reads, a lack of notice, however, does not necessarily void the trial court's judgment because due process requires that the method of service be reasonably calculated under the circumstances to appraise interested parties of the proceeding and afford them an opportunity to present objections. So again, guys, case law to support that. Now let's go to page 3. Right, let's pick this up at the top, and it reads, in this instance, however, the record does not reflect any method of service of the notice of trial setting. There is no record that a notice and or order of hearing was ever filed or sent to appellant. Then it states, although a recitation of due notice in a judgment is some, but not conclusive, evidence of proper notice of trial settings and hearings, case law to support that, it states, the rule does not apply to default judgments. In an attack upon a default judgment, a recitation of due service in the judgment does not lead to a presumption of due service. Again, guys, case law to support that. But let's continue. And they still quoting more case law, and it states, instead, the plaintiff must, quote, prove that the defendant was served in the required manners. But let's continue. It states, given the facts before the court, the OAG concedes that appellant's rights to procedural due process may not have been upheld, and that, therefore, the default judgment rendered November 12, 2020 may be voidable. So again, guys, because the OAG voluntarily and clearly violated my ARC's procedural due process, right, back in November 12, 2020, and they still violated his his procedural due process in the motion to terminate that we did, you see, in the lower courts. But now that we're in the higher courts, which is the Court of Appeals, now the Attorney General is trying to recant the statements that had happened in the lower courts. So now he have to concede to the truth, because now he can't find any written rebuttals to rebut what we wrote in our initial appellant's brief. But let's continue. Then it states, appellant's choice of procedural vehicles. Then it states, appellant titled his pleading motion to terminate. That is true, guys. The first thing we filed was a motion to terminate for the same reason that we mentioned in the appeals brief, right? But instead of the lower courts doing the right thing, in the lower courts, and the Attorney General saying this in the lower courts, no, he agreed with everything the court said in the lower courts. But now that we're in the higher courts and they're forced to answer these questions in the appeals court, now he recants his statement, and now he agrees with my ARC that they clearly violated his due process. But let's continue. Then it states, appellant titled his pleadings motion to terminate. Then it reads, as though it were a motion to terminate the parent-child relationship under Texas Family Code Section 161.005. So he's trying to say, because he filed a motion to terminate, they trying to say that the court took it as a motion to terminate the parent-child relationship under Texas Family Code. But we did not quote Texas Family Code 161. So there's no way that they can construe the actual motion to terminate the original motion to be construed as to terminate the parent-child relationship underneath Texas Family Code when we didn't quote that code at all in our documents, guys. But let's continue. Then it states the reporter's record of the de novo hearing on this motion demonstrates that after the appellant raised the notice of issue, it states the district court judge states, and quote, so this is what the district judge stated in the lower courts when we did a de novo hearing for the motion to terminate. And the district judge simply states what? There is a proceeding that you can address that with, and it is not this proceeding. So again, the lower court judge said that he couldn't address these same arguments in his motion to terminate, right? So we said, okay, cool. Let him continue to make his bogus ruling, and we're going to appeal it and go to the appeals court. So again, we're reading now to see the Attorney General's response, and the Attorney General is simply agreeing that his due process was in fact violated, and they should have did this in the lower court. But again, they didn't want to do the right thing, so we continue to go higher and apply that pressure. But let's continue. It states the OAG, but now let's go to page 4. Let's go there. We're on page 4. Pick this up at the top, and it reads, the OAG understands that the appellant raised this procedural due process issue within a legal action entitled Motion to Terminate. However, under Texas Rules of Civil Procedure 71, when a party has mistakenly designated any plea or pleading, the court, if justice so requires, shall treat the plea or pleading as if it had been properly designated. But that's what they didn't do, even though you can file a motion to terminate at any time to terminate the void support order. So it was still the proper motion. So by the judge by the Attorney General trying to say it wasn't a proper motion, it was the proper motion. It's the point that they were trying to railroad my arc in the lower courts. And we simply said, okay, we're not going to take that. And we went to a higher court. But let's continue to read what the Attorney General states. Then it states, the OAG requests that this court dispose of this appeal in a manner in accordance with the law and the facts cited above. So again, now the Attorney General wants the appeal disposed of. Why? Because the Attorney General concedes and what? Accepts defeat. And it's just that simple, guys. But let's continue. Let's read number 3. Number 3 states what? Assertions regarding the appellant's errors in his first 2 issues. So now he wants to address the errors in the first 2 issues that I went over. But let's continue. It states, there is insufficient evidence in the record to support appellant's first 2 issues. So now they're trying to say it's insufficient evidence in the record to support the first 2 issues. But, you know, even if it wasn't insufficient evidence in the record to support the third issue, then why did they still rule against my arc in the lower court on his third judicial challenge? Because it was all set up, man, and they was trying to intimidate him to stop him from continuing his fight, because they want him to simply take the laws. And like I tell you guys, they feel as though once you lose in these lower courts, you don't know what to do next. So they'll say, well, once he loses, he's going to accept it. The time going to run out is going to become a final order. He can't do nothing about it. No, not here. We know what to do when things like this happen, and then when the courts don't want to do what they're supposed to do. We know how to go higher and go to these higher courts to get this remedy. But let's continue. Then it reads, there is insufficient evidence in the record to support appellant's first 2 issues. Then it reads, appellant asserts in issue 1 that the trial court error when it entered the November 12, 2020 default judgment based on the null and void marriage certificate. That's exactly what number 1 states. The first argument was whether the trial court's error when it entered the void order based on the null and void marriage certificate, which they did, guys. And once we get the final order from the appeals court and my aunt come and give his testimony, he's going to give you guys the rundown of what happened in this case. But let's continue. It reads, in issue 2, appellant asserts the trial court's error and abused its discretion when it entered the November 12, 2022 default judgment by entering a default order without properly establishing paternity and parentage. So that is true, guys, because the trial court and the appeal court have to go with that, because how can you enter and establish paternity if you violated his procedural due process, the same procedural due process that the Attorney General just concedes to admit to being true and that they actually violated. So if they violated due process, then that means that what? By the violation of due process of his rights, then it has to undo what? The paternity as well. Because paternity cannot be established, procedural due process was violated. You see, so his arguments to try to protect from not ruling with 1 and 2 doesn't make sense, because once you void somebody's due process, then you cannot proceed forward in any other type of manner against that individual. And it's just that simple, guys. But let's continue. Then it states, in issue 2, appellant asserts the trial court erred and abused its discretion when it entered the November 12, 2020 default judgment by entering a default order without properly established paternity and parentage. Which again, guys, what I stated before, which is true. You cannot violate his due process and still say that they acknowledge or establish his paternity. No, that's wrong. But let's continue. Then it states, next paragraph, the district court denied the appellant's motion to terminate and adopted the finding and orders of the associate judge. However, there is no record of the September 2nd, 2022 proceeding on the motion to terminate in front of the associate judge. So again, if there was no record of the September 2nd, 2022 hearing before the associate judge, then how can the associate judge still make a ruling adopting the lower court's decision, which doesn't make sense, guys. But let's continue. Then it says, proceedings on the motion to terminate in front of the associate judge. Then it reads, based on the associate judge's report, the associate judge did make these findings. Number 1, the hearing was set on father's motion to terminate filed on March 8th, 2022. Number 2, the courts found that paternity was established based on Texas Family Code subsection 160.204, presumption of paternity. So again, the court found a ruling on presumptions of paternity, right? Meaning they assumed that paternity is there, not that they proved paternity. No, it's a presumption of paternity. It wasn't proven. It's just an assumption and presumptions, like I tell you guys. But let's continue. Then it reads, the court finds that the parties was married and the child was born during the marriage. So there's no way that the court can find that they was married and the child was born during the marriage if the court clearly violated his procedural due process. The court doesn't have a right to even hear the case or proceed forward in the case without procedural due process being first established, guys. So again, that rules out the paternity issue and the marriage issue and everything else that we addressed in points 1 and 2. But now let's go to page 5. Page is up at the top of page 5. And it reads, number 3, the court found that the mother made an oral request for DNA testing and the father did not agree to DNA testing. Number 4, based on the court's finding, the court denies father's motion to terminate. So now, if the Attorney General is clearly admitting that they violated my ox due process, right? But then, come to find out the child's mom is requesting for my ox to take a DNA test, but my ox declined taking the DNA test. So the court says, because he didn't want to take a DNA test, they said they're going to force him to be the father because of the void marriage certificate. But remember, guys, all this stuff is being done, even though they're violating the due process, the same violation of due process that the Attorney General is simply admitting to, guys. But let's continue on. Let's read number 4 again. Number 4 states, based on the court's findings, the court denies father's motion to terminate. Right? So that was the lower court. But let's continue. It reads, according to case law, an appellate court may reverse a trial court for abuse of discretion only if, after searching the record, it is clear that the trial court's decision was arbitrary and unreasonable. Case law to support that. Then it states, hence, the party that complains of abuse of discretion has the burden to bring forth a record showing such abuse. Case law to support that. Then it states, absent such a record, the reviewing court must presume that the evidence before the trial court judge was adequate to support the decision. So again, guys, if there was no record and the court did not record this hearing and there's no record to place before the associate judge, then these case laws actually don't apply to that matter. But let's continue further. Then it states, here, the appellant has the burden of showing such abuse of discretion. Then it states, but brings no apparent evidence of these two issues, right? But he can't bring evidence on those two issues because there is no record for the hearing of that day. But let's continue. Then it states, as there is no record on the September the 2nd, 2022 proceeding. So the attorney even knows this. But let's continue. Then it states, and as the associate judge's report makes explicit findings against these two issues, the reviewing court must presume that the evidence before the trial judge was adequate to support the decision. As such, the OAG cannot concede on these 2 points. Then it states, possible error due to lack of record of September the 2nd, 2022. Then it states contested hearing. So now the Attorney General is trying to say there may be a possible error due to the lack of the record. But the same record that he's trying to argue to state that the Attorney General, that the Associate Judge didn't have. But let's continue. And it reads, the OAG concedes that the error may exist based on the lack of record. Right? Then it states of the September 2nd, 2022 proceeding before the Associate Judge. So again, guys, that's page 5. Now let's continue on to page 6. We're almost done. Let's go to page 6. All right, we're on page 6. Let's pick this up at the top. And it reads, under Texas Family Code, section 105.003C, in a contested hearing, quote, a record shall be made, as in civil cases, generally, unless waived by the parties with the consent of the court. So in my Ox case, when he contested the hearing, they did not make a record, you know, and there's no waiver of him stating that he waived them from making a record, okay? But let's continue. And it states, in this instance, the Associate Judge's report does not indicate whether the parties waived the making of a record in this contested hearing. As such, the record does not reflect whether there was a proper waiver. However, as there was a record of the District Court de novo hearing, this may be harmless error under Texas Rule of Appellate Procedures 44.1. So again, guys, you all see, like when the courts make a mistake, they call it a harmless error. But that harmless error cost my Ock 3 years of paying child support. He's been on it since 2020. Okay, he did not receive remedy until 2023, and we're still waiting for the appeals court judge to make a ruling after the Attorney General already filed a concession. So again, guys, you know, this is the things that they're doing, and this is the wicked ways that they're acting, okay? But again, I like to give all glory and honor to the Most High Yah, because without him, none of this would be possible, okay? And, you know, I'm going to keep applying pressure and showing you all these remedies. But now let's go to point number 4, and it reads again, reiteration of what? Concession. What is concession, guys? We know that concession is what? Acceptance of what? Defeat. That's it. That's all. But let's continue. And it states, based on the foregoing, the OAG narrowly concedes error as to concerns raised in Appellant's Issue 3. The likely deprivation of procedural due process due to lack of a post-answer notice of hearing. So again, guys, that's all I'm going to do for today, right? As you all can see, I crossed everything else out, such as the attorney name and everything else. I crossed all that out. So again, that's all I'm going to do for today. If you all need my help, hit me up in my email at yahismagnified@gmail.com, guys. Also, cop that merch, okay? I'm going to continue to apply pressure. 2023 is starting out good already, guys. I already posted my first testimony for 2023, and now we're getting more results in the appeals court. This time we're coming out of the state of Texas, baby. Like I tell you guys, man, we apply pressure in every state, no matter what state you're in, guys. You can get remedy. You got to be willing to just go through it and fight that good fight. So again, that's all I'm going to do for today. If you need my help, hit me up in my email, yahismagnified@gmail.com. With that being said, again, cop that merch, and I say shalom.